and I've come to programs here quite a bit, so it's a lot of fun to actually be on the other side of the podium for once at this library. Okay, so I don't know how much time I have, but I don't have much time this morning to just sort of introduce us to this question of constitutional interpretation and also constitutional meaning. So a couple of things about what I'm going to do. We're gonna look at those convention documents, which are really pulled from the notes of James Madison. And we're going to talk a little bit about the source work there. But I also want to talk about how we interpret the Constitution as a whole, how it is we put meaning to the various phrases of the Constitution, but not only that, how we give meaning to the entire document. So I'm sure everybody here teaches the Constitution quite a bit. You are familiar with it. I'm hoping that we can have a kind of brief discussion about how historians work on this subject. So, that being said, I tend to talk fast. I tend to go through things fast. You can raise your hand to have me clarify anything. I will call on you as soon as I possibly can. And if not, and also I tend to work interactively, so I will be asking questions and kind of hoping for a lot of hands to go up. I'll try to spread around comments to as many people as possible. But let's consider this an interactive session. And really, to begin, I guess we have to get to this central question that we're asking: the relationship of slavery to the Constitution. What is the Constitution when it comes to slavery? And I might start off with two statements about it that we could consider as sort of meta statements about the meaning and purpose of the Constitution. And the first would be that the Constitution is a pro-slavery compact, made for slaveholders, made to keep them in power, and largely successful at keeping them in power until the Civil War. The second statement might be that the Constitution was a glorious liberty document, one that celebrated equality, that stood at its root, and by its nature was anti-slavery. All right, so you can obviously see such two statements are completely incompatible. The fact of their incompatibility is one of the things that we're here to look at. And one of the reasons I start with this is because these were two positions which by the 1840s in the United States marked the central opposition points in developing constitutionalism. And just to give you an idea of how important this is for what we're doing, people moved along a spectrum of understanding the Constitution that went from a pro-slavery document on the one side to a glorious liberty document on the other. And none more famous than Frederick Douglass himself, who began as a constitutional thinker, espousing the argument that the Constitution was a pro-slavery compact, irredeemable at its core, and ending with the belief that it was a glorious liberty document that did not support slavery at all. So we have people moving across this spectrum, we have people arguing across this spectrum, and in my work as an historian, I have tended to find that it is the argument about the Constitution that is most interesting. Now, just a quick question kind of to get us going. How many of you actually just sort of like curl up with the Constitution, read it at night, or no? Okay. Well, maybe, how many of you are familiar with it? You know how it starts? Or how, okay, so you kind of, it's a nice thing about working with teachers. Go ask an average American audience this. And I mean of citizens, not of immigrants. But go ask citizens what the Constitution says. Most of them, of course, don't know. They usually think it starts with what in the course of human events or something like that. You know. So we have a slightly better understanding of the Constitution, but we want to get to a question here of constitutional interpretation. So I want to run through an exercise. We're going to look at various ways of interpreting it historically. And that's really what we're here to do. We're looking at the Constitution as a political document, as a legal document, as a social document. And I make the argument, I believe this to be firmly true, you cannot understand the Constitution as theory. You must understand the Constitution in its historical context. Theories are built about the Constitution, pro-slavery theories, anti-slavery theories, but ultimately they come back to the historical roots of the Constitution itself. When we're talking about constitutional meaning and we're talking about historical meaning, I want to differentiate between various means of understanding it. First of all, when we talk about the intent, I know everybody has heard this at some point, right? This isn't what the founders intended. I don't know how many times I hear this on CNN, or I shouldn't watch CNN, but I use that as a standard. But if you watch the news, there's always going to be some pundit that comes back to this. This is not what the founders intended. First of all, they don't know what they're talking about. They don't know who the founders are. What they're really talking about is the framers. And the framers are a distinct group of people who were present at the Constitutional Convention in Philadelphia. Those were the framers, nobody else. That means, by the way, that Thomas Jefferson is not a framer. He wasn't there. He sat that one out. So did John Adams. By the way, and I don't mean that they're irrelevant or their thoughts are irrelevant, but they weren't framers. They didn't write the document. So when we talk about intent, we're talking about what the framers intended when they drafted the Constitution. Another form of understanding historical meaning is to look at understanding. And this, when we talk about original understanding, we're talking about the Ratification Conventions. And actually, I'll kind of throw some stuff in as we go along, just hopefully you'll all enjoy it, maybe you won't. Sometimes they're cute stories, sometimes they're not. But the idea of ratification, does anybody know where that actually comes from? I mean, constitutions are brand new in the 1780s. This was a brand new procedure that was thrown out. It was supposed to be Congress that determined whether or not they would amend the Articles of Confederation. And instead they throw it to the states and put it into ratification. It had been pioneered in Massachusetts as a way of differentiating a constitution from a statute. So that's how new everything is in 1787, 1788. Nobody quite knows what they're doing. And nobody's had these ratification conventions before. They don't know what they are. So these people show up and they debate the meaning of the Constitution. They do it in every state except Rhode Island. If I say except, it's usually going to be Rhode Island at the end of that. They refuse to hold them. They vote it down. North Carolina holds one and does vote down the Constitution. So we don't have a unanimous process with that. But they understand a document that they have no idea what the intent of is. Because there is, of course, that very famous vow of secrecy that is taken at the convention. So the public meaning of the Constitution is very different in some ways from what the intent was. And to be perfectly frank, it was this original understanding that drives a lot of early constitutional theory, because they don't have Madison's notes yet. All of the records from the Constitutional Convention, the official record and Madison's notes, all of those were essentially kept secret for about 30 years. They eventually start releasing them. And I'm going to talk a little bit about what that means in a second when we go over Madison. We can also, I made the statement before, the rather provocative one, that we can't understand the Constitution as theory. I don't want you to misunderstand me. This doesn't mean that the Constitution doesn't have words that we might interpret. There is constitutional text. And the first rule of construction is one known as, this is if you're reading statutes, the first rule of construction is called plain meaning. If the text has a plain meaning, you don't have to go anywhere else to determine what it is. You can just take the plain meaning of the text. You know, if you say that a president must be, what is it, 48 or something this year? I always forget numbers. But whatever the age is for the president, you don't have to sit around and debate exactly what 39 is or what president means in that context. It has a plain meaning, and we can all agree on it because we're smart individuals. Even the dumb ones can agree on the plain meaning. There's also the spirit to the text. When the text does not give you a firm idea of what is there, you might think about what the purpose of the text is. And another rule of statutory construction, and it's a rule that is applied to constitutional construction as well, is that when something's ambiguous, you interpret it in such a way that it will further the spirit of the law. If you have a law that is intended to provide health care for everybody, and you are interpreting in this 1,000-page bill these little provisions, and you don't know quite how to interpret it, you give it the construction that's most favorable to furthering the end of extending health care to all, right? Does that make sense to everybody? So when you're interpreting those ambiguous provisions of the Constitution, you need to know what the purpose of it was. And by the way, the moment I lay that one in, can you see why it was important to people from 1790 to 1860 about whether this was a pro-slavery compact or whether it was a glorious liberty document? It really mattered to them. These were not academic debates to them. They were very serious because it would indicate how they would construe a very ambiguous text. There's a couple other things you can think about with constitutional interpretation, one of which is structure. And this gets to be a little bit more complicated, but where something is in the Constitution matters. What's in Article 1 of the Constitution? Legislature. What's in Article 2 of the Constitution? Executive. Article 3? Article 4. The interstate and federal state relationships. Very good. Article 5. Amendments. Article 6. Yeah, it's like miscellany. They got the supremacy clause in there, some other things. Article 7. Ratification. By the way, this was a very intentional structure. It was an intentional structure. I have a short video on this that I put up on the Slack channel that you're all welcome to watch. There's an aesthetic component to it. There's a reason why it's organized in this way. There's actually a fair amount of aesthetics involved in making the Constitution not just a legal document, but a beautiful document. And so the structure actually fits into part of that. Okay, so that being said, let's do a quick sort of exercise on constitutional interpretation and look at a clause we don't use very much, the guarantee clause, which is in Article 4, Section 4. United States, can everybody read this, or probably not, I don't know. I'll read it aloud once. The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. What does this mean? What's a rational interpretation about what this allows? Or what the purpose of such a clause might be? Go ahead.
The federal government is going to protect the state governments and protect them from being overtaken by outside powers.
Okay, yeah. So this is a protective clause, right? So this way, oh yeah, go ahead.
Oh, or inside powers.
Or inside.
Like enslaved people.
Yeah. Well, okay. So now that raises another question: Who are they protecting against here? Now this is a reasonable question. Now here's something that you might ask from 2018. If we have an epidemic in Georgia of domestic violence, what does that mean? Yes?
Probably interpreting to mean like spousal abuse.
We probably have a lot of spousal abuse and child abuse if we're talking about domestic violence. Does the United States have a duty to protect the state against this domestic violence? It's in the Constitution, isn't it? Why is that a bad interpretation? And clarify the they.
That's not what the framers of this clause
Well, I'd argue you could take that one step further and also say that that's not what anybody understood at the time, right? So if we're talking about, and you nailed it, intent and understanding, we can eliminate that. Domestic violence acquires a meaning. And today to talk about domestic violence is not to talk about an uprising. At least not in 2018 in the United States. It's to talk about the home. And it's to talk about a category of crime. But nobody can straight-facedly give it that interpretation. And this is, just to give you an idea, here is the guarantee clause in the convention. On August 17th of 1787, they took up the clause. That was one of the original versions of it, where it said that they shall protect each state against foreign invasions and, on application of its legislature, against domestic violence. And then you have Mr. Pinckney. This is from Madison's notes. That's Charles Pinckney. We'll learn quite a bit about him. He's a South Carolina representative. Plays a big role at the Constitutional Convention. He moves to strike out on the application of its legislature. Why would you do that? Just kind of curious here. If you look at that original language, so it's here, the application of its legislature. Protecting the state against foreign invasions and against domestic violence. Why would you want to strike out on the application of the legislature?
Would that be read or considered that the federal government is going to help someone over the state government?
Okay, so I'm not sure I would get that interpretation out of it. Here, basically, he's saying we're going to take away a layer of protection. The layer of protection being that the federal government can't declare a state of domestic violence wherever you are and then invade you. I mean, that might be your concern if you are a state's writer, right? So here he is, maybe suggesting we need to take off this one layer. Any other ideas about why he might do this? By the way, I don't have an answer to this. It's just it really is an open-ended question. Yeah.
Perhaps he's concerned that where the power lies in the legislature, these might be the sorts of individuals who might be most affected by an uprising, therefore unable to apply.
Okay, all right, so we've had two interpretations. Do we have a third?
I don't know, but my first thought when we read it initially was that it might take a while to deal with your legislature if your state is in unrest, so you want quick action.
Well, what happens if that uprising happens in June? There's no legislature in session. And believe me, the first thing you do in an uprising is not say, quick, call the legislature. It's the last people you want coming anywhere near you in some kind of crisis. And that, by the way, and if you look further down here, Mr. Ellsworth proposed to add after legislature or executive. And then they eventually clarified this. Or the executive when the legislature is not, cannot be convened. You look at the final language over here. So if you start looking at what they start with and what they end with, you get an idea of what it is that they're trying to do. And yeah, they are really trying to protect against potential insurrections from below. Now this is kind of fun. If you look at Patrick Henry, you all know who Patrick Henry is, right? Patrick, he's my favorite whipping boy in the founding era, in part because he can take it. I mean, the man was like 6'5", the best speaker of his generation. He was a powerful man. At the Virginia Convention, he leads the Anti-Federalists. So this is the guy against Madison, and against the whole panoply of the people we call the founders. And he's there arguing constantly against the Constitution. And here he is arguing against the Guarantee Clause. He singled this one out for a program. And he points out that if there's an insurrection in Virginia, and there should be danger apprehended of insurrection in another state from the exercise of the government, or suppose a national war. And then he goes on and says, if Congress calls out the militia, whose commands will the militia obey? Our commands, the commands of the state, or the commands of the government? Well, if this Constitution is supreme, they must leave the state in the middle of an insurrection and go and put down an insurrection or guard against foreign invasion of another state. So here he is casting doubt on the Guarantee Clause as a fundamental attack on state sovereignty, which is what he did quite a bit. So again, it's like it shows that there is a good deal of concern, even here, about in a clause which is more or less designed to protect the states. Here is a slaveholder in Virginia concerned about the implications of the Guarantee Clause. Now, and of course, we mentioned this before, with the structure of the Constitution, we note that it's in Article 4. This is not outlining a federal power, therefore, or a congressional power necessarily. It's about how the states and the federal government are going to manage their relations. So we can look to structure to help to understand the Guarantee Clause. When we talk about the spirit of it, we can think about this in terms of two things. First of all, the preamble to the Constitution, but also that the Constitution was correcting the defects of the Articles of Confederation. This is a very common argument. I'm sure you teach this to your students quite a bit. By the way, this is how we know James Madison won. He's the one who says, hey, there are all these problems with the Articles of Confederation, and he just keeps saying it over and over again, and then everybody buys it. I'm not saying it's not true. Maybe James Madison is wrong. but he really won. We still teach that to this day. That's a pretty powerful thing. But it is instructive to look at the fact that Congress had no way, absolutely no way, of providing any defense for any of the states, or really for coercing the states to put their militia into service. And so the guarantee clause in this category kind of makes sense there. But look at the clause one last time. We've been talking about domestic violence. What else is in the guarantee clause? Come on, somebody who hasn't spoken yet. Go.
Guaranteeing every state has a Republican form of government.
Which means, sorry California, we've got to change your legislature, switch your party affiliation. What does that mean? That you will guarantee a Republican form of government. Looking to all my people who haven't raised their hands, but I'm not getting it. Yes.
It sounds like a direct protection directly on the people against the state government, which may resort to more European tactics.
What do you mean by European tactics?
Oligarchical, aristocratic, misogynistic type practices, where if the power ever gets away from the sovereignty of the people within their own state, then this is a blanket guarantee that power can be restored to the people.
Did this happen? That's very good. Did this happen in antebellum America? Did we have an instance where a state had a non-Republican form of government?
Wasn't that the case in Pennsylvania?
How so?
So democratic.
Oh, well, Democratic can be part of Republican.
Overly democratic.
Well, so talk about broad construction. It's like, well, that Constitution is too democratic.
Harming the rights of the sizable minorities.
Sure, actually, put that up there for a second. We're going to hold that. It's not what I was thinking of, but that's an interesting idea.
Massachusetts, after Boston,
That's okay. Well, I hadn't thought about that. So here's a guarantee to the states that the United States won't subvert its Republican governments. That's also built into the structure as well. That's a good point, because that was first and foremost on everybody's mind was the absolute power of Parliament and its ability to suspend the entire government of Massachusetts. Okay, I'll just go ahead and cut to the chase. I was thinking about Rhode Island again, but I was thinking about the Dorr Rebellion. It doesn't make the standards. A lot of people don't know about it or teach about it that much, including, by the way, college professors. It doesn't fall into the major textbooks, but in the 1840s, there's a huge rebellion because by 1849, Rhode Island still doesn't have a constitution. Oh, excuse me. They don't have a written constitution. And so there's a referendum held and a constitution's voted in, but the old government says, oh, no, we're going to continue this revolt. And you have warfare in Rhode Island. And there is an application that is to be made to the United States. And the question is, who does the United States support? Which government do they get involved in? Which one do they come forth and support in this? They stay out. The United States doesn't send anybody, and there's actually a court case that comes out of this, and the court case goes up all the way to the Supreme Court of the United States, and this is where we get our political questions doctrine. The Supreme Court actually steps back. The case is called Luther v. Borden, and the Supreme Court says, hey, that's for the political branches to decide. The Supreme Court isn't in the business of telling people what a Republican form of government is, or which government to support in a situation like this. So if it's a political question, they say, we won't touch it. Okay? What's really interesting to me about this is that another group seizes on the Republican government, the guarantee clause, and its guarantee of a Republican form of government, and that's the abolitionists. Because they make the argument, and it's not an unreasonable argument, that all of the slaveholding states do not have Republican forms of government. Large swaths of unrepresented people. They have laws in place that prohibit discussion of the most important public policy issues that are before them. They are illiberal in the extreme. They're essentially one-party states. They don't make the standards for Republican government. Now, this argument does not get any traction until the Civil War. And then, when the Civil War is concluded, the guarantee clause is pulled out by the radical Republicans, and they say, we have all the constitutional power we need to reconstruct the states and to give them true Republican forms of government. So this clause actually gets inspired with new meaning, well beyond everything we discussed, which was very close to what they discussed back in the day.
That question. Is this with the term Republican as a Republican Party?
No. It's not that they say you need to have a Republican Party government. They just say they're actually looking at it in the classical Republican sense of the term. But they believe that slave oligarchies were not Republican governments. And so I just want to illustrate that the meaning actually can change. They can actually think about how it applies to new circumstances, and they do. And of course, when looking at the guarantee clause and back at that original meaning, keep in mind, this was a period of time, and by the way, this will play into my discussion about slavery in the Constitutional Convention. It's worth thinking about. What was the international context? What position was the United States in 1787, 1788? I mean, think about it now. What are we right now? We're the world's bully. You know, we can stop the United Nations from recommending breastfeeding. We can start trade wars. We've got the big bad nuclear arsenal. We can do anything we want, or so we think. We have a lot of power. Another way to put it. What power does the United States have in 1787? I see a lot of shaking of heads, which I think is exactly the right reaction. The United States is weak. It is a poor country. It's oftentimes called the best poor country in the world because there's a lot of resources, everything except human resources. So there are. It's a place that is constantly being threatened. If I had a map, I would. I should have. I don't know why I didn't put any visuals in this. I usually have visuals, I swear. My students aren't this bored most of the time. But if you look at a map, it's, on every side there is an imperial power. And each of those imperial powers has networks that far outweigh anything the United States has. And they are all circling, waiting to take pieces of the United States away from it. And you can see the Congress struggling with this in the 1780s, trying to negotiate treaties when it can't even control the states, trying to get foreign governments to recognize their sovereignty. This is a lot of fun. After the Peace of Paris, the British say that they're going to vacate all of their forts in the old French territory and the new American territory. They hadn't left those forts. That's why one of the reasons we have a war in 1812 with the British. American sovereignty was a joke. It was a complete joke. So yeah, they are really, really struggling here. So you have to think about the guarantee clause as a way of saying to all the states, we can create a better protected society to ensure all of our survival. By the way, which states are going to need that more than others? You would think. They're always at the end of the discussion here, and they never seem to come around. Yeah, Rhode Island would definitely need protection. You can carpet that state, it's so small. I mean, it's a... Okay, anyway, so, but what other states? What other states?
Wasn't South Carolina pretty worried about Spain?
Why is South Carolina, another state too, by the way, we're in that state, Georgia. Why are Georgia and South Carolina potentially worried?
Well, we had the Spanish in Florida, so they ended up fighting going back there, trying to see who was going to St. Augustine versus that whole fight, trying to see who's going to take Florida. And of course, Spain eventually lost, but at that time, nobody thought Spain was going to lose.
The big empire. Yeah. Oh, and another thing. What's the little town just north of St. Augustine? Mosaic. Mosaic is a town that is founded largely by fugitive slaves. And they are running from Georgia and South Carolina, and the Spanish grant them amnesty, and they become a frontline protection for St. Augustine. So if you're coming by sea, it's much better to be able to land and come in through the north. And Mosaic is this protective settlement. And that is a beacon to people in South Carolina and people in Georgia who are enslaved. So there is a deep concern that Spain is going to siphon off even more disaffected enslaved people, and that will be at some point a launching point. And then what do you have in South Carolina? Do you have a population of Spartans ready to go out? And no, you don't have much population there except for your enslaved. And they are all very, they will talk, by the way, in various ways about their relationships with the enslaved, the slaveholders will. But when they talk in the Constitutional Convention, when they have unguarded moments, they're very clear about the weakness of these states and the necessity that they have for a protective association like the United States. There's a reason, in other words, why the South Carolina delegates are the big nationalists in 1787. Willing to sacrifice state sovereignty, by the way. In fact, thinking that it'll go away. It's not really all that important. What's important is that they get what they want out of this Constitution. Okay?
I'm just spelling that soon.
Oh, M-O-S-E, and it's got a name that's about 2 lines long that I can't remember off the top of my head. It's like St. Ignatius de Mose, it keeps going and going and going. It's a typical kind of medieval style name, but it's just shorthand as Mose, M-O-S-E. And I'd be happy to share, there's a wonderful article written about it. I forget where it's published. But it's a fascinating point that it's there and that we don't really think about it. But it has an impact on what's happening at the Constitution Convention. All right, that was longer than I thought it would take. But do we have any questions coming out of this? Yeah.
I have a question. So at the very beginning, we talked about intent versus understanding. And if I heard you correctly, you said that the people at the convention were going on understanding of what happens in the Constitutional Convention. And as you were talking, I was thinking about the Federalist Papers and how we have a direct statement about the framers' intent of the Constitution. How did that play into the state's understanding of the Constitution?
What a wonderful question. Because, and by the way, I think the Federalist Papers are a wonderful collection of writing. It's really high Enlightenment politics. It really is a rare moment of brilliance. John Jay, Alexander Hamilton, James Madison, it's wonderful. What was the purpose of the Federalist Papers? I'm going to start by asking a bunch of questions, but I swear to God I'm getting an answer. What's the purpose? What do you mean though? Ratification? Convincing people to vote. In other words, is this a concordance of the Constitution? No. Is it written necessarily to tell us what the framers intended? That is what their stated purpose is, and they say that over and over. We're going to explain this to you. So we're going to demystify it, make it known what we mean by this, right? Who is it that they're trying to persuade? Yes?
Then the people who would be voting to ratify, that's who they're trying to persuade.
They're in a debate. They're debating Brutus. They're debating the other anti-federalists who are writing papers that are saying, my God, this government is going to take away our liberty. It's going to create an aristocracy here in the United States. That's what this government is going to do. You have your own Republican government and they're taking it away from you. And this is their response. No, we're not. Let's explain how all this works. It's brilliant writing, but we have forgotten that it is positional. Now, and by the way, this is another case where James Madison, Alexander Hamilton, everybody else with the Broadway hit wins. They win this argument, and they do it the right way. They publish right afterwards. They collect all of those essays, which were scattered across newspapers everywhere, and then they publish them as the Federalist, not the Federalist Papers. A little bit of, cocktail trivia you can have. Not known as the Federalist Papers. It was the Federalist, and they published those essays, and they kept republishing them and republishing them, and the Southern States writers, led by people like St. George Tucker, Patrick Henry, John Taylor of Caroline, real big thinkers in the antebellum era, couldn't stand this. And they wrote constant diatribes. And when the convention notes are released, they read them and go, they lied in the Federalist. And then they publish books against the Federalists saying, nobody should be reading this. This is not the way the Constitution is to be understood. It's a very interesting sort of thing. So it's a great question. And yes, when you read it, I think what you have to say is, within its context, they are persuasive papers, written by framers, no doubt, and written to persuade people that this is what what they're voting on is what they want, what will be the best for them. Yes.
How about circulating voting anti-federal British papers? Did they get out there?
Yes. So there is this project called the Documentary History of the Ratification of the Constitution. Hopefully within the next 10 years they'll digitize it. Right now it's still in written format. It's a 30-year project to get every piece of paper connected to ratification into a set of volumes. I think they have 30 volumes or something like that. And volumes like this, not little volumes, big, thick volumes. They produce so much paper arguing about ratification. It's a wondrous thing to think about a society that put this much energy into political argument and productive energy. Not pundits screaming one-liners at each other and tweeting back and forth, but real thinking about what these things meant. And by the way, some of their arguments come across as ludicrous, but they argue back and forth and they republish essays. So and this is what the Documentary History of the Ratification does. It tells you where they were published, and then in notes it'll tell you other places that the same essay was published. You want to hear something real fun? So there are these essays that are published in Pennsylvania early on, because Pennsylvania has a very early ratification debate, and there are these long letters, no mention of slavery. Same letter is reprinted in Massachusetts 3 months later, and there's a whole paragraph at the end talking about the Constitution's relationship to slavery. So they edit these documents as they go along. They change them for their audiences. It tells you that there is a larger anti-slavery population in Massachusetts than there is in Pennsylvania. All right, so these are all contexts. There are contexts about what is being ratified, why it's being ratified, what people think about it, what's important to them. All right, we ready to move into the actual documents? Oh, I should very quickly say that there are some meta-interpretations. We will be dealing with them in this class. And really I want to get to the two main ones, which were put forward by scholars in the 1960s, 70s, and 80s. So these are arguments which are being refined a full generation ago. And they work something like this. There was an argument about the Constitution that said it was more or less slavery neutral. This was put forward by Stanford scholar Don Fehrenbacher, by William Freeling, and other historians. And the way that argument runs is something like this: that the compromises about slavery that are in the Constitution actually represent compromises. So in some ways the slave states win, in some ways the free states win, and when you look at them all together, what it does is create a situation where really things could have gone either way. Now, both Freeling and Don Fehrenbacher and virtually every other historian who subscribes to this thesis says that within 20 years, it is unmistakably pro-slavery. So after 20 years of operation of the federal government, the government is completely pro-slavery. But it's a political process, they say, that creates this. And so the Constitution itself sits in a kind of position of neutrality. Against this argument, quite famously, William Wiechek and Paul Finkelman argued very strenuously that the Constitution was a pro-slavery document. In other words, that and by the way, they launched this argument in its full-throated nature in 1988. Why 1988? They were writing from 1970, like in the 1970s and 1980s. Why publish all these essays in 1988? The bicentennial of the Constitution, of its ratification. So here comes the bicentennial, the ratification of the Constitution. There's all this hagiography, and people are singing and dancing, doing their parades and everything. And out comes these arguments, the Constitution, a pro-slavery document. William Wiechek had a great one titled "The Witch at the Christening." Yeah. It's like this is the history that they're telling everybody. And what they did is they made the very powerful argument that these were not compromises. They were not compromises. Each of them reflected distinct victories by the forces of slavery that had virtually no opposition because there was no anti-slavery element at the Constitutional Convention. That is true. I have yet to find a dedicated anti-slavery contingent at the Constitutional Convention. So there's a lot of truth to these arguments. Yeah.
Do you mean beyond the people who kind of railed against it that had slaves themselves?
Oh, you mean George Mason? Yeah.
Yeah.
Mainly George Mason, and we'll go to we'll go to that in just a second because we have that excerpt. George Mason delivering the anti-slavery speech. The largest slaveholder in the United States at the time, delivering the heralded anti-slavery speech.
Well, Gouverneur Morris, though, he was pretty raw, down and dirty about his anti-slavery sentiments. A lot of backhanded comments about, here's Butler. Was there just no rally around him?
So, that's the thing. You don't have a faction. The South Carolina delegates are united. They are united, and they go in united, and they are singular in purpose, and they claim to have North Carolina and Georgia in their pockets, and they probably do. Oh, by the way, Gary Nash, I don't know if you know him, UCLA historian. I managed to go 8 years at UCLA and never once met the man, so I have no idea what he looks like. But Gary Nash wrote a fantastic book about this that was just based on a couple of lectures, and it was a counterfactual thesis. He just said, everybody says that you have to have these compromises because South Carolina kept saying, me and Georgia, we're going to leave if you don't do this. He said, okay, let them go. Why didn't somebody just say, let them go? They weren't going to make it on their own. How would they make it if there's a United States to their north and Spain to their south? They're going to be picked off in no time. Call their bluff, is what he was saying. And that actually gets to another aspect of the Constitutional Convention about the way things played out there. There's a lot of parlor in it. A lot of what happens at the convention doesn't happen in the convention itself. It happens at the dinners afterwards, which they finish at 2 o'clock every day, so they're out having dinner and drinking a lot together and forming alliances. And there's a lot of card games that are being played. Real-time sort of gambling. So there's something to be thought about this. South Carolina and Georgia managed to really push their connections in a way that maybe people could have pushed against harder if Gouverneur Morris has support, if there is an anti-slavery movement. And we'll talk a little bit more about the origins of abolitionism and how that intersects with this in a later session. Finally, there's a couple of latter-day iterations of these various arguments, and this is largely where my scholarship falls. I don't ask the question anymore, was the Constitution pro-slavery? I don't think it's answerable. I think we have 2 arguments here, both of which use the same empirical evidence and argue it in a different way. I think it is far more interesting to think about when politics works the way it does and when constitutionalism works the way it does. In other words, it's interesting for me to look at the ambiguities in the Constitution and to see how people resolve those ambiguities. And if you look at that, you find some very interesting things about the change that occurs in American constitutionalism. And I'll have more to say about that throughout the course of our meetings. But suffice it to say that you could be a relatively anti-slavery Southerner in 1788, and you couldn't be in 1861. That's an important change. That's an important change. And it's only one of many. The other is that, kind of last thing to talk about is popular constitutionalism. This is a phrase that anybody is familiar with. Okay, which is fine. But it gets back to a fundamental principle that I want you to think about, and that's judicial supremacy. What does judicial supremacy mean? Maybe you don't know that one either. Yeah.
That the Supreme Court decides on matters of the Constitution, whether something is unconstitutional or
Right.
constitutional.
Yeah, and that's probably what everybody thought, right? Even if you hadn't maybe heard the word judicial supremacy before, that's largely what it says. I always ask the question of my undergraduates, who tells us what the Constitution means? And they all say the Supreme Court. The Supreme Court. It's not true. It's not true. We have a certain amount of deference to Supreme Court opinions, but I'm here to tell you as an historian, on every major issue that has divided this country, it is not the Supreme Court that gets to settle the matter, and they have never settled the matter. If you want to think about it this way, look at what happened when they tried to step in and settle the question of slavery in the territories and of the citizenship of black people, which they do in Dred Scott in 1857. That did not work. And in fact, we'll have Martha Jones here, who's just written a book that is so new we couldn't even get it to you. It's so new that I don't even have it. It's called Birthright Citizens. And one of the things that she catalogs is the responses to Dred Scott. In other words, not even the courts, not even the Maryland courts, were willing to follow Chief Justice Taney's opinion in some ways. Later, Jim Crow segregation. If you think for a minute that the Supreme Court had a choice in 1896 when it decides Plessy versus Ferguson, you're wrong. It does not have a choice. It would not have had an impact. It was not that constitutional process. It was not determined by the courts. And we can talk later about the court, by the way, does get a lot of power in post-war society. So we definitely have a different situation with Brown v. Board of Education and other decisions. But anybody who has followed the subject of gay marriage or the subject of abortion and looked at the Supreme Court's rulings on it knows that it doesn't stop when the Supreme Court issues its ruling. They are, despite being 9 black-robed rulers, as Elena Kagan just called them and herself, despite that, they are not some kind of clerical council that ultimately we all refer to. Popular constitutionalism is the idea that in the end, it is through various popular means that people will express constitutional desires. So it's not just a matter of the Supreme Court saying the Constitution means this. It's about people saying, I'm going to elect people who are going to push my interpretation of the Constitution. And this, by the way, is largely why we have a lot of debates right now about the Second Amendment. We have a very active group of people in this country who have pushed an interpretation of the Second Amendment and gotten a lot of elected officials to exactly represent that view. And that is one of the reasons that state legislatures have passed the laws that they passed. That's a constitutional process, however you follow, whichever side you follow. Same is true of gay marriage, which was actually, although it was a court that initiated that, you start to see first in corporate America and then in states a complete pushback against the Defense of Marriage Act, which was passed by Congress. So this has a lot of parallels today, this idea of popular constitutionalism. In this era, it's everything. Congress matters more than the Supreme Court when it comes to important constitutional issues. And that's why we're going to take a really hard look, not just at court cases, but at how the Constitution worked in Congress and how it worked in the streets. Okay? Okay, so now we get to the actual documents, which I'm sure you all stayed up late reading last night, are now ready. But and we don't have a whole lot of time because, Cara, correct me if I'm wrong, I gotta be wrapped up in the next 20 minutes, right?
That is correct.
Okay.
15, we have to leave.
Okay, so I don't have much time, but this will give us a way to start this. And I want to start with the 3/5 clause. Now, the 3/5 clause, you need to understand a couple of contexts of this. And June 30, I excerpted this June 30 debate because it's important to think about, this is where Madison makes a comment that has been cited by people ever since. And nobody, by the way, had this comment available to them until Madison publishes his notes. When does he publish his notes, by the way? After he dies. It's not, I think, until 1837, 1838, that they finally put together a draft, the final draft of Madison's notes, and publish it. We don't have them before that. He didn't put them out there. So keep this in mind. It's not till later that we get this comment. Which comment, or here it is, I actually extracted it. He refers to himself in the third person, but and I just make clear, Madison was talking about himself in the third person, that he contended that the states were divided into different interests, not by their differences of size, but by other circumstances, the most material of which resulted partly from climate, but principally from the effects of their having or not having slaves. How do we interpret this? What does this mean about the Constitutional Convention? And here, why don't we just throw out some interpretations?
I was just gonna say, like, oftentimes we teach that it was the large states versus the small states, and that's why the compromises were around, but I think Addison's suggesting it's not about slavery.
Okay. All right, so everybody heard that, right? That, and by the way, that is key evidence used by Finkelman and Wiechek and others to show that and I could not have put that better. That was exactly the way it was put. Yes?
Can you argue also that this is a result of taxation and how to interpret taxation because they were using...
They're not talking about taxation.
Well, but...
They bring that up later.
Right. But in the context of how are we going to determine what the true population of the state is? And are we going to do that by counting every single person? But some of these people we don't necessarily consider citizens per se because they're not property holding, they're not male. So how do we rectify who in fact lives in the area?
You just brought up another really important point. We're talking, okay, so it's true that if they're going to do direct tax, it's going to be on apportionment, no question about that. So they have the issue of taxation looming, but if you look to this day, and you have the June 30th text, if you look to this day in the Constitutional Convention, it's very clear they are not talking about taxation. They haven't brought that up yet, okay? However, that does not mean you cannot put forward the argument. It's in the back of their minds. It has to be in the back of their minds, okay? But we can distinguish between text in that case and maybe a reading of the text, a suggestive reading of the text that comes from behind it. We can think about a couple of things here. I want you to think about it this way. The larger context of what's happening here is that the framers are in the middle of a power grab. Now, everybody should know this story, right? They show up in Philadelphia, and they have very specific instructions. The delegates from Delaware are told if there is a sacrifice of equal representation, by which they mean equal state representation, you're to walk out and leave. Which would tank, and they all think that would tank, right? Because they need a unanimous consent to do this. So you have this larger problem. And this is why they hold it in secret. It's why the Virginia plan just sets aside the Articles of Confederation. And I think this is one of the reasons that first argument about the large state, small state persists so much, is because the real power they're talking about with proportional representation is going to take away a lot of power from small states. Particularly, and here's where it's important to think about, which states are the small states that are really going to suffer from this? You know Rhode Island. Rhode Island is going to suffer. They don't even show up. So they're not here to even complain. What else? No, Massachusetts is a big state.
Delaware.
Delaware's one. Yeah, Georgia, New Jersey, maybe Connecticut. They're kind of a middling state.
So this is always go back to the question. When we consider small versus larger, we consider land size or we consider population? Okay. So, and that will go into the other question of when we consider population, are we talking about everyone that's considered a quality citizen? Are we considering just who's in the state? I think that goes into the three different components.
That's exactly right. Because and think about this for a moment. Because if this is going to be the basis of power, you want the largest population you can muster. You certainly don't want to count voters. That's a very bad idea. You are then excluding women, children, unproperty. It's like, ooh, you want to count as many people as possible and get representation on as many people as possible. And so that sits at the center of this. Virginia is leading this fight, by the way. This is not a South Carolina issue. Virginia is the largest state. And I think if you take off their slave population, that was its own state, it would still be like the fourth largest state. I mean, they're like two large states put together. So they're going to demand, and it is absolutely clear that they will not surrender the idea of some enumeration, some kind of counting for their slave population, right? What I wanted to point out about this statement, I mean, that's exactly right. And so far, I think we've laid on the table a lot of the immediate context. If you look at the actual debate, I had this question listed up here. What are they debating on June 30? before and after Madison steps in. Those of you that took a look at it, what's the specific nature of the debate? Yes.
The amount of delegates that they were going to have,
Mhm.
that would determine like your voting power in this
Yes.
course of events.
Now, in other words, they're having a debate, and who is it squaring off against who? You've got the small states lining up saying, we're not sacrificing our power. You're asking us to give up our power and get nothing in return. We can't do this. And the large states say, but justice. But, it's unjust to have Virginia and Delaware represented at the same level. It's undemocratic. If it's popular sovereignty we believe in, then we must allow the people to be sovereign. So they're doing these very kind of popular arguments and justice arguments, and the small state people are saying, how? And then what does Madison say? He comes out and says, hey guys, the large states, small states, you aren't the real problem. The real problem is over here. It's that what we have are two different economies. We've got a northern economy, we have a southern economy. This was interpreted by Brown historian Gordon Wood. If you've ever seen Good Will Hunting, he's the one that Dan Damon mentions. He's also a Pulitzer Prize winner, so he's a fairly well-known historian. But Gordon Wood, Jack Rakoff, and other historians all put forward the interpretation that what Madison was doing was a little bit of sleight of hand here. Look over here. Don't look at the large state, small state issue. That's not what really divides you. And they've interpreted this to mean that. Now that's a pretty bold interpretation, but believe me, it's orthodoxy. It's long stood as orthodoxy, at least for those that have disputed the pro-slavery constitutional thesis. Yeah, I'm not asking you to buy it, by the way. I'm putting it out there for you to listen to. Yes.
Were there? I'm guessing. In my head, I thought that most of the large states were the slave states. That's not. I guess I'm just thinking about Virginia.
Not South Carolina, not Georgia. Certainly
They're
not
not
Georgia.
technically big states. They're not.
South Carolina, and well, here's the thing. If you don't count slaves,
Right.
they're nowhere.
I guess that's.
Yeah,
Right.
and they are well aware of this. And by the way, we are talking about power here. There's a reason why the Constitutional Convention spends more than half of its time dealing with representation. This is going to be the locus of power, how you put people into Congress. Solving this issue, both the small state, large state, but also apportionment and whether you count the enslaved. Those are the key questions, and they take until July, and when they're finally done with this, the first thing they do is take a vacation. They are so tired after having dealt with it. One more thing I want to put out here. Oh, yes?
Yeah, but it seems like they want to count over those easy counts, right? So you exclude Indians not paying taxes.
Well, there's another reason for excluding
Well,
not paying taxes.
treaty obligation rights and all those other things, but they wanted to count who was easier to count.
Well, I mean, outside of Indians not taxed, who are they not counting?
But the point is that if you look at some of the states and put Indian populations into their counts, it would have changed the whole dynamic rather than that. Most of Indians in Massachusetts were wiped out already by this point, but not in Carolina and Georgia and Missouri.
I admit I've never heard that.
Not even North Carolina had been wiped out.
Yeah, I mean, I've never heard the idea that they might have counted. I don't even know if anybody broached the idea.
Yeah, they always exclude
Yeah.
Indians not paying taxes.
Okay, interesting. Oh, yeah.
Can you clarify that? I don't have a history background, so whenever that came up, I didn't know.
Oh, the Indians not taxed?
Yeah.
So the final 3/5 clause enumerates, you count everybody, and then it just says 3/5, there's an exclusion. And the exclusion is for Indians not taxed. And what that means is that you have some assimilated Indian populations, and they're taxed like normal citizens and people, but the Indians not taxed live in their own tribal governments, and they have treaties with the states and with the United States, and they essentially are their own country, even though they would live within the territories of the state. Does that make sense? Okay. Yeah, that's a whole other institute. It's trying to deal with that situation. Yes.
With my students, one of the things to do, and maybe I'm oversimplifying an incredibly complicated situation, but which we have to do all the time anyway. But
Yeah.
I mean, I go back to that, the phrase "a bundle of compromises." That the way the bottom line, I kind of walk out. I say, well, nobody walks out of there happy, which is in a way a signal that your compromise sort of worked. That nobody gets the entirety of their agenda. And looking at what the Madison statement here, and whether he's doing sleight of hand or adding to the idea, like I do a little miniature simulation where each kid is playing a particular state, and so who are you going to identify with, and how to separate them by population, and you got the large state, small state, then there's the slave owners, and some of them, they have to change locations, and we have like the cross-cutting cleavages that occur as a result. And even, I think it was Franklin who proposed at one point that state delegations be determined by the amount of wealth.
Yeah.
Which is another factor that that one lost out, but it's a compelling one. That if Virginia and Massachusetts are providing so much income, and still to this day is an issue where you have the states that are not getting their bang for their buck from. Anyway, I'm meandering here, but I just think it's an interesting. Trying to put this into the larger context of whether there was any conscious attempt to confuse the issues, you don't want all of a block of states to stay together if you can force them to be divided on different things. It makes it easier to find middle ground, because similar to the simulation that we're going to be doing, where you want to play one off against the other.
Well, okay, so I think that's I think that there might be a lot of truth in that. And certainly that sits behind this interpretation that Wood and others have put on Madison's notes. That Madison shows these divisions and very craftily can try to divert people into other kinds of divisions so that you can ultimately craft this kind of a compromise. And I think what you described is probably, in some ways, quite close to the truth. Don't forget, however, though, they don't know what representation means. These are new. This is the 18th century. Europe is a monarchical world. There's no idea of popular representation there. And don't think that Parliament had anything to do with that. It was all a bunch of ancient liberties and privileges and franchises that are represented in Parliament. So the people aren't an active force until right now, and they're just figuring this stuff out. I have 10 minutes, so here's what I'm going to do. This next part is really cool, and I want you to think about this. What are Madison's notes? Let me just put it to you this way. When did he write the notes? He does it on 3 or 4 occasions. He goes back and completes the notes. He revises the notes. Why was he writing these notes in the first place? Now, I'm not going to answer all of these questions to your satisfaction right now, so I'm just going to give you the really good part of this. The idea of taking legislative notes on what a legislative body was doing, was kind of a new thing, but it was something that people did. It was like a diary. He was keeping them for his friend Thomas Jefferson. And he was going to send them to Thomas Jefferson so that he could keep up with what was happening. He goes back several years later and starts editing and filling them out. And it's only then that he starts thinking about posterity. And what's really curious is that he adds an awful lot of stuff at that point. And here's the really cool part. Mary Sarah Bilder, historian at, I don't know where she is, brilliant historian, went back and looked at the actual handwritten notes. And what she found was that he started adding things in 1790, and a lot of the phrases that he adds come right out of congressional debates at the time. And a lot of what he adds has to do with slavery. And so you start to see, and he puts words in his own mouth that can be traced directly to debates in Congress in 1790. It is very curious. In other words, I think that the argument she is making, she's careful not to make too strong of an argument in any one direction, but I think what it demonstrates is that within 2 years of the Constitutional Convention happening, there was a greater national consciousness about what slavery was and what it meant in the Constitution. And he goes back and very consciously starts crafting his notes. And I think one of the things that he wants to make sure everybody sees is that there is some sort of anti-slavery MO at the Constitutional Convention. So, apologies to Pulitzer Prize-winning Gordon Wood and Jack Rakoff and others. They've been reading the notes as if they were some kind of transcript. They aren't a transcript. They're written by a human being. They're the best record that we have of what happened at the convention, no doubt, but that doesn't mean that they are some kind of copy that we can read as an unvarnished record. They exist in their own context. Yes?
So then that also means that they're subject to bias as well, because we have to think of Madison's own bias when writing them, and then years later, afterwards, he may have had a different bias than he originally had as well.
Yes. Yeah. I mean, that's a question of memory. It's a question of memory. And your memory of an event is always changed by the intervening events. It's also changed by a fundamental human attribute, which is one of the reasons that you teach history, and that is that we are hardwired to read things as narratives. That is, we don't understand something as human beings. I mean, this gets back to primitive brain level stuff. Anthropologists have worked on it, psychologists have worked on it, and people will tend to put things into stories, and that story then helps us discard evidence that doesn't agree with it and put evidence in that does. And we are constantly formulating these stories. Yes?
In my reading, didn't I read where they appointed somebody, was an honorary position to take the notes, but he was not very eager and active and aggressive in doing that?
He was just a lousy record.
But don't you think they could have, in your opinion, shifted that to somebody who would have been an active note keeper?
Would have been nice. Okay, I got 4 minutes. Marissa?
Just a quick comment.
Sure.
As a teacher, when I use primary sources, that's one of the hardest things for me to get kids to understand that there's a bias. I think it's really hard for me to like scaffold that into their understanding. Just like they were there, that's the story.
Right. That's a really hard one. I have the same problem. In trying to get my students to think about this. And just when you get that exercise on them and you think they've got it, then they read their next source, and it's like they never did it before. It's hard. We should all talk more about that. It'd be great to have some informal conversations about how to teach this. Can I take my 4 minutes? Okay, I'm going to totally railroad you and go forward. Slave trade clause. The 3/5 clause, I do want to be very clear here. The 3/5 clause was probably what they call a sine qua non. I don't think you get a constitution without some sort of representation for slaves in it. There's just too much. I mean, it's very clear that when you're dealing with power, you're dealing with power. And people were not going to sacrifice that kind of power, even if there was an active anti-slavery element in the Constitutional Convention. But the slave trade clause is very, very different. And I want to be very clear about this. The slave trade clause protects the slave trade for 20 years. Now, you can make the argument, and some academics have made this argument, that the real context is to compare the Articles of Confederation with the Constitution. And under the Articles of Confederation, Congress could never end the slave trade. But under the Constitution, they could. They just had to wait 20 years to do it. And, well, 2 other things. First of all, we get the slave trade clause out of the Committee of Details report. There's 2 real important, there's a bunch of them, but there's 2 real important committees. One's a grand committee that comes up with the 3/5 Connecticut Compromise. The other is this committee of detail that takes all of the little disparate bits and then produces a report so they can actually debate the Constitution. They meet after the 3/5 clause is decided, and they come out and produce this report. And the slave trade clause is in Article 7. This is later what will become Article 1, Section 8 of the Constitution, so it's about the legislative powers. And these are the sections that are in it. Enumerated powers, a definition of treason, the 3/5 rule is extended to taxation, no export taxes, no taxing of the slave trade, no banning of the slave trade, no capitation tax except in proportion, a 2/3 requirement for any navigation act, that's any commerce act. Okay, any regulation of international trade, you need a 2/3 majority, and then no titles of nobility. How many of these clauses favor the slaveholding states? And no fair saying that the treason definition defends it. That one doesn't. Irrelevant. Which ones directly affect the slaveholding states? Number 3, number 6, number 4. Yeah, okay. 3, 4, and 6 definitely. You might argue 5 as well, but really those are matters of general concern. But it's very important to them. They are exporting states. They are exporting states. They depend on a staple export. They want free trade. They want to get their goods out with no export tax attached to it. That will hurt their pocketbooks. And they don't want any laws restricting where they can sell their trade to. So they want to make sure they've got a veto, and that's what the 2/3 majority essentially says. If we block against it, you can't pass it. Now it's important to notice that a bunch of these go away. The 2/3 rule goes away. The export tax, however, stays in. But what they end up with the Fugitive Slave Clause is a kind of a compromise on that. There's actually several compromises in here. Because I'm out of time, I'm just going to go ahead and tell you what they are. The compromises that come out of this, they are allowed to tax the slave trade. So the tax is imposed. The 20-year limit is a little inexplicable to me, because this was one area where Virginia could have told South Carolina, forget it. You know, we're not going to. If you guys can fight as much as you want, but we want this ban, and it's very clear that they want it banned. By the way, why does Virginia want the slave trade banned?
Internal trade.
Yeah, and this is pointed out. If you read that section that I gave you, somebody points out after Mason delivers this beautiful speech against the slave trade, that infernal traffic, and he goes on about the immorality of it. By the way, they were all aware of this. At least the slave trade they were aware of was horribly barbaric. So here he is inveighing against it, and I think somebody points out that might be Oliver Ellsworth says, oh, does that mean that your slaves will be more valuable now that nobody can import other slaves? There's a little economic interest in it for the Virginia planters as well. So that's important to see. But there's another compromise in here that people kind of forget. The first is that the prohibition on Congress simply says that they cannot prohibit the migration or importation of such persons as the several states shall think proper to admit, nor shall such migration or importation be prohibited. However, this was actually a weak rendering of the language. And here's why it's weak. What if the state outlaws the slave trade? It can do it under this clause, right? And what if Congress passes a law aiding the state in guarding against the introduction of slaves? It can do that as well. And fun fact, every state closed the slave trade well before the 20-year mark. And in fact, Congress passed laws that allowed naval vessels to patrol and pick up slave traders. And they did this. It was only South Carolina that reopened the slave trade in 1804. So it's a clause that actually allowed for a lot of wiggle room. There's also this other thing about, why do they say migration or importation? Well, that's what abolitionists will say later on. And of course, the pro-slavery forces, slave states in the 1830s, when that argument was brought up, say, oh, no, this is all about the international slave trade. And they had a huge debate about the meaning of migration or importation. It's a huge debate over this significant. Okay, I can't answer that right now. No, I just don't have time. But you're exactly right. Then the question, there's a flip side to that question, and it is, if you are a free black person, can you travel from state to state? Or can you prohibit the migration of certain citizens? That's an issue in the Missouri Compromise, because Missouri has that clause, and it's an issue for thereafter. We will talk about it. Finally, the last one is the Fugitive Slave Clause, and I'll talk a little bit more about this tomorrow during a brief session where I talk about the origins of anti-slavery constitutionalism. And the reason I'll hold it for that, well, two reasons. First of all, I got a whole chapter in the book, which I hope is well written, that you can understand it. But I got a whole chapter about the original meaning and understanding of this fugitive slave clause. And I run through all these kinds of interpretations in there. So hopefully that will help you understand what the original meaning of this was. And another very important part is that this was the one clause of the Constitution inspired by the nascent anti-slavery movement. The idea that free jurisdictions could offer freedom to people who came to them. And this is right out of the Bible, by the way. Everybody should know the clause. No, maybe not. There's the wonderful verse in Deuteronomy about when the fugitive comes to your home, you offer the fugitive asylum. And so this is something that is just being experimented with. And I'll talk more about that at a later time. I've run out of time. Cara's angry with me. Thank you all.